Good afternoon and welcome to the BDO Talking Trusts Information Sessions. This is part one of a four-part series where we host guest speakers who are experts in trust law and taxation and who will share practical information and insights aimed at helping you navigate your duties and responsibilities of being a trustee. I am Ricardo Teixeira, Chief Operating Officer for BDO Wealth Advisors, and I'll be your host and facilitator for the Talking Trusts Information Sessions. Thank you for joining the conversation. This webinar is live now and is being recorded and will be shared with you after the event. We have set aside 15 minutes for an interactive question and answer session following the talk. So please do line up your questions in the queue during the talk, and you can do this by using the Q&A function on your screen. You'll find it on the top right of your screen. Look for the question mark in the two speech boxes. BDO has been providing professional audit, advisory and tax services to families and businesses for over 60 years in South Africa. There has most certainly always been a focus on trusts. However, of late, both SARS and the Master of the High Court appear to have raised the stakes and the attention to the governance and administration of trusts. As we know, trusts are unique structures, each one defined by a bespoke and customized trust deed. So as a result of this attention by SARS and the Master of the High Court, it has unfortunately revealed many shortcomings and failures by trustees, many of which have had devastating consequences on the original purpose and intent in establishing the trust. With tax reporting season just around the corner, our objective in hosting this information series is simply to raise your awareness, knowledge and understanding of the best practice and benchmarks for good governance and overall compliance in the administration of a trust. By knowing what is required and having the right solutions and processes in place, trust can be extremely beneficial to a family's wealth creation and protection. We start off the series with today's topic, the burden of trusteeship. Often a spouse or child, family member, or even a family friend would accept trusteeship without realizing the burden that comes with this role. Most accept trusteeship, but try to claim ignorance when things go wrong. Unfortunately, that's no longer a defense. Trustees are expected to actively participate in trust matters and should not leave the business of the trust in the hands of others. Move to our next slide. Our guest speaker today is well qualified to speak about trusts. She is a chartered accountant with a master's degree in local and international tax. She is also a registered fiduciary practitioner of South Africa, a master tax practitioner of South Africa, and a trust and estate practitioner. Besides being so well qualified, she's truly passionate about educating and guiding all role players in the trust industry in South Africa. You will often read her opinion in the personal finance section of the weekend newspapers, and she has also published a book, Demystifying Trusts in South Africa. Please welcome Thea van der Spy. Thea will take a practical look at the role of trustees and unpack the pitfalls and potential problems when a trustee does not know the full extent of their responsibilities.
Good afternoon from my side. Thank you for making the time to invest your time to learn more about trust in South Africa. Thanks for the invite, Ricardo. 30 minutes is really short. I was so hoping you could give me more, but at least I got another session later on. So I think we'll use this first session just to get you a good introduction in terms of trust in South Africa, a touch on trustees' duties, in terms of the legislation in South Africa. We're also going to look at the obligations and the expectations of trustees. I'm just going to today give you a very short trustee checklist, and then obviously in the second session we go into more detail into what you have to do that's required for the administration of a proper trust. So let's just look at the landscape of South African trusts. Those numbers you would see is quite scary. These are all estimated numbers because we've got different masters offices, each one keep their own registries, and it is really difficult to get a finite number. but it is estimated there's about 720,000 trusts registered with the master, of which only 330,000 registered with SARS as income tax payers, and of those, only 85,000 submitted their tax returns. So you can see the level of compliance in South Africa is 12%. That is pretty scary, especially when we know that SARS has made all sorts of sounds to have a closer look at trusts, to have a closer look at historical wealth. So the compliance is a great issue in South Africa, and we'll unpack in the slides why I believe the compliance is as low as 12%. Apart from the fact that the compliance is a problem, the legal fraternity is also of the view that about 90% of the trusts in South Africa never came into existence due to bad drafting. So that's a completely different issue, which we won't really address today, but I think that's why it is so important to read the trust deed, and you'll see later on we'll speak specifically, where trustees have a responsibility to actually understand their trust deed. So the 90% is an absolutely scary number, because that may mean that you may have moved all your assets into a trust, and when it is attacked, it may be problematic, and then that trust may be declared null and void. So when we look at it, trusts are really actually largely unregulated in South Africa, and I think that's contributing to just this complete grayness. People don't know exactly what they have to do, what's expected of them. So you can just move to the next slide. So when we look at the limited legislation in South Africa, trusts are largely unregulated, which frequently leads to their abuse. I think people who know enough about trust know exactly kind of where the loopholes are, and how trust forms are often abused, and beneficiaries don't get what they're entitled to get. The law of trust are contained in the Trust Public Control Act. Now that is the act that regulates the administrative aspects of trust. It only contains 27 sections. It's an extremely short act. It's not well suited to kind of our modern trusts. The master is looking at a project where they're going to improve on the current act, and hopefully that will give better clarity. And I think enforcing the master's powers in terms of what they can do, typically with trustees who don't fulfill their legal obligations. When we look at trust, we also have to make sure that we understand where they are referenced in other legislation. For example, the Income Tax Act. Trust is defined as a taxpayer, so because of that, it has to register for tax, and there are certain ways in which SARS want us to treat trusts as far as they are taxpayers. And then we also know about the whole connected person rule that's particular to trusts, and which is very, very hard to actually understand and to identify the transacting parties with a trust. So I think let's consider some of the common challenges that we see in South Africa. We know about a lot of people in what we see where multiple trusts are set up for people. I think people a couple of years back got really carried away when they go to trust seminars, when they're approached by lawyers, accountants, and then typically they end up with multiple trust structures. It's often lay persons. They don't understand the law, they don't understand trust, so it sounds like a nice idea. You end up with all these multiple trusts which you don't really know how to execute, and then that comes to our 12% compliance in a way, because people just don't know what they have to do with it. We've spoken about the bad drafting. That's really problematic, and we often see clients never ever read the trust deed. They just assume whatever the lawyer, the accountant, whoever drafted the trust deed, did the right thing. Often vanilla trust deed templates are used that's not tailored, as Ricardo referred to, tailoring trust deeds around specific family needs. So bad drafting is really a big problem. So once you have a badly drafted trust deed, to execute that just becomes a mess thereafter. So I think that is the starting point, is to get a properly drafted trust deed. And then, yeah, after you've been to your lawyer, you know, they push in your hand a set of trust deeds. We never educated. They never tell us what we have to do. We'll see later the trust have to be registered for tax. We have to open a bank account. We have to physically manage this thing. It's not like a will that, you know, people just put in a bottom drawer and now they know they have a trust and, you know, that's enough for them. There's a lot that has to be done. In fact, you'll see later, there's much more required of you than what you're actually managing a company or a close corporation. There's much more that you have to do, you know, rather than just the basics. And then the accountants, the lawyers, the financial advisors are not really working together. You would go to your lawyer typically to go and have the trustee drafted. You would, you know, go to your accountant and say, no, I have to execute this thing. You're a trustee. Everybody works in silos, and it really becomes a problem because the different role players don't talk to one another. And I think when the issues start popping up, you know, then those professionals are nowhere to be found, and the poor trustee, often in South Africa, the family members have to answer to SARS, to the master, and they just don't have enough information or made an effort to understand the trust deed and to actually understand their obligations. Then, unfortunately, you know, there is a lack of discipline. I think we're all very busy, and apart from the fact that people don't know what they have to do, it's something that you always leave for later because it's never priority. So I think the lack of discipline, the lack of compliance by trustees is a big problem, and it's going to be very simple. SARS indicated they're going to ask simple questions. Have you had that one compulsory trustee meeting in the year, which your trust deed, so by the way, enforces or requires you to do? If you haven't had that, we are just going to assume this trust is an alter ego trust, which is something we'll explain later, but basically the trust form is disregarded, and those assets are then included in the person's estate or income, etc., for tax purposes. So it is crucial to you know, get the discipline, to get a proper system in place, and to make sure you comply. So I would take a hard guess and say about 95% of trusts in South Africa are just not governed, you know, to the level that they actually have to be governed. So I think once we understand the different trust role players on the next slide, I think that will help clear a lot of the confusion. A lot of people don't really understand the different roles, you know, between the founder, the trustee, the beneficiaries, in terms of, you know, who has got, you know, any authority to make decisions, who can override. Some of the older trustees have got fancy mechanism where the founder, who's also often a trustee, can just kind of hire and fire trustees, can make decisions, can veto decisions, can go really crazy. So the sole purpose of a founder is to establish a trust. That is the role that the founder should have. We should be very careful in the trust deed even to reserve rights for the founder, you know, without running into trouble for SARS. Then the trustees and the beneficiaries, because often in South Africa we deal with a lot of family trusts, that line really gets blurred. So people, the ownership, the control, the enjoyment is in one pot. People just can't, you know, recognize which hat they put in on. And the moment you speak as a trustee, you cannot think about my own enjoyment from the trust assets. You only, the ownership based in the trustees, you have to control it. The beneficiaries have got absolutely no say in terms of what has to happen with trust assets. So the trustees are the sole controlling entity of the trust, and then the beneficiaries must have the enjoyment. And we'll speak about it later, but that's where the courts have got tired of this whole mixing up of enjoyment and control. So as early as 2005 in the Land Bank case, the court said that it would really be nice if you have something as an independent trustee, because that would break that line. So the enjoyment would be separated from the ownership, the control, the decision making. And we know that later on in March 2017, the Master issued a directive where he now requires every family business trust you know, to have an independent trustee, a new family business trust. But we've seen, you know, existing trusts where we start, you know, changing trustees, they also ask now for the appointment of an independent trustee. So the Master is really driving hard to break that line between ownership and control, you know, from enjoyment. So I think if trustees understand that role, I think you kind of halfway there. The moment you move into the beneficiary side, when you start making decisions, when you have to favor one beneficiary over another, that's where the problem starts. So so having discussed the role players, I think for today let's have a closer look at just the role of the trustee specifically. We'll go to the next slide. Right, so first of all, as I said, the trustees are the custodians of the assets of the trust. They have to take transfer of the asset, they have to take ownership on behalf of the trust. They have to keep an asset register to disclose to the master and any interested party which assets the trust hold, and it's a requirement in terms of the Trust Property Control Act to have an asset register. They do not necessarily have an interest in the assets, as we said in the earlier slide. The enjoyment is separate in the role, but we're not disallowed to be a trustee and a beneficiary. And I think that's very important, because a lot of people say, "Ooh, I can't be a trustee and a beneficiary." There's sufficient legislation that says it's all okay. In fact, we can be the founder, the trustee, and the beneficiary, as long as we're not the only founder, the only trustee, and the only beneficiary, because I think we know that a trust deed is a contract, and just normal contract law, you cannot contract with yourself. So just by design, there has to be three different parties in the boxes, but you can be more than one. You're not disqualified from being a trustee or a beneficiary, or if you're one or the other. So when you look at the fact that it's allowed to be a trustee and a beneficiary, specifically now we start blurring those lines again, because whose hat are you wearing? It's very important to be careful of any conflict of interest. So on the next slide, when we look at the conflict of interest, trustees have to as a starting point, protect the value of the assets. I think that's the overriding purpose that trusts are set up normally, because that is why you set up a trust, is protect your assets, right? So as to protect the value almost at all costs. Then there's also, an expectation from trustees to grow the value. Now, trustees can say, but if I need to protect the value, I can't invest in too risky investments, because now I may even lose my investment. So versus I really need to take the risk, because I now can grow the value of these assets. So there's a very fine balance, and you need to be able to apply your mind in terms of how have you arrived at that decision to actually invest in a certain asset, for example. So you can see there's just a natural conflict between protecting the value of the assets versus growing the value of the assets. And there are court cases where beneficiaries have even attacked the trustees on investing too conservatively. So you need to be careful. You can't do nothing. So if you're sitting on cash, for example, in a trust, you have to be able to demonstrate that you've applied your mind in terms of the strategy in the trust and why you've taken a certain action. And I think throughout the thread is documentation. We have to be able to prove every single decision, every single action we've taken in a trust, so which we will see later. And then, I think mixed with how we treat assets, we now need to meet the needs of the beneficiaries as well. So then we're going to, especially, most of the trusts in South Africa are discretionary trusts. That means that trustees have a discretion to favour one beneficiary over another. And there's also plenty of court cases where, trustees have favoured the one beneficiary over the other, and they couldn't demonstrate that they've properly applied their minds. So, that is something, and most of the purposes of the trusts are to actually look after the welfare of beneficiaries. I think that's a very important thing, and you need to be able, we can't just go and protect and invest assets and grow the value and, let it be stuck for many, many years while we know the children are at school, at university, and if the trustee made specific provision for education. So I think it's very important to kind of balance those natural potential conflicts. So let's have a look at what is expected of a trustee specifically, and then we get into a little bit more detail. So I think it's common knowledge that trustees must use greater care in handling trust property than they might in dealing with their own property. So if you just think about it, what you would do if you consider buying a property or selling a property, you know, the kind of things that you would anticipate, the kind of questions that you would ask of a trustee. It's expected to go a step further in terms of, going back to the previous slide, is, am I preserving the assets? Am I growing assets? Am I really looking after the benefits of the beneficiaries? So it is very important that you must take absolute care when you're actually making trust decisions. The exercising of independent discretion. There's also a lot of court cases around that. Often in South Africa, we have the father or the mother who's the founder of the trust. That's typically your major trustee, your dominant trustee. And, you know, we speak about the puppet trustees, that's the rest, the mothers, the children, etc. And even sometimes the so-called independent trustees, they just do what the founder wants them to do. So it is absolutely important that you can demonstrate that you have applied your independent discretion. And then it's also important to ensure the interests of the trust and the beneficiaries are protected at all times. So whether we're investing, whether we're selling, you know, the beneficiaries are at the center of every decision that you have to make. And then, of course, we have to avoid any conflict of interest. That is a conflict, you know, for example, I am a trustee and now I want to buy the property out of the trust. I mean, the courts go as far as saying you have to apply to court to get approval to buy that property out of the trust. So it is very important that whatever you do, you actually, you know, anticipate and consider any potential conflict of interest. And then trustees also have to act in good faith. So that's on the next slide. You know, that always you have to demonstrate that you act bona fide and in good faith in managing the affairs of the trust. In other words, you can't have your own hidden agenda. You can't, you know, benefit economically from this trust alone without considering, you know, is it in the best interest of the trust? So good faith is absolutely important. And then the absolute overrider, the Trust Property Control Act, Section 9(1), which a lot of people don't know about or just conveniently forget, is it's in the Trust Property Control Act that each trustee will act with a care, diligence, and skill which can reasonably be expected of a person who manages the affairs of the other. So we've spoken earlier about the care that must be greater than you know, the way you deal with your own assets. I just had a look at the definition of diligence. I mean, it's crazy words. You know, you have to act with rigor, meticulousness, carefulness, thoroughness, attentiveness. So I think if you just think about to what extent you have to go when you actually, you know, participate in trust decisions, etc. And skill, the Trust Property Control Act requires skill. So you can no longer say, I have no idea how a trust works. I don't understand trust deeds. I don't understand, you know, what I have to do. As Ricardo said earlier, it is no excuse. So it is absolutely very important that you have to have skill. It's much, much more than just good faith. The legal responsibility of trustees that they have to show they've got a fiduciary duty is the next slide. That is a legal requirement of trustees to act in an ethical way, you know, when they deal with other parties. They have to take care of the money, which is the trust money. Our law, actually, there's court cases where contingent beneficiaries have got a right to have, you know, the trust assets looked after in a proper way. So that is the legal responsibility that trustees have. And because of that legal responsibility, you know, trustees can be held personally liable. So, and although the fiduciary duty doesn't require skill, that's in the Trust Property Control Act, you know, when somebody attacks the trust or want to go after the trustees for making bad decisions or decisions that are not recorded properly or not done in terms of the object of the trust, you know, they can be held personally liable. So I think that's very important to understand. So where's the starting point for trustees? We've had a look at legislation, we've had a look at all the issues. So often people say to us, but where do I start? You know, what do I do? So I think the first starting point is to understand and execute your trust deed. That is the way, kind of the place to start. Because there's such limited legislation, it's very important to actually, revert to the trust deed, because in there, hopefully, things are better laid out in terms of what has to be done, etc., etc. So, trustees have to really understand, different things. I think powers in the trust deed is a nice, thing to look for. That can tell you exactly what you can do and what you can't do. A trustee, if you've got a discretion, you can't just accept you've got a discretion to do whatever you want. You have to be empowered in the trustee to do it. I think it's also important in the execution, and once you have a system in place to make sure that those powers, can limit you in terms of what you can do, what you can't do, because people don't know and they just go ahead and do transactions, and later on, it's not allowed in the trust deed, and they may be null and void. The whole process to follow to appoint trustees, how you have meetings, processes to follow for meetings. How many trustees have to sign agreements? I mean, it's very practical things. All those things you should get in your trust deed. Requirements to make distributions. Some trustees are very specific in terms of how distributions are to be made, processes to follow, who to approve. The signature of documents is another very important thing, is to look at who is required to sign documentation. If the trust deed is very specific about that. Accounting and auditing, does the trust records have to be audited? Not a requirement, so by the way. Or can you just do the accounting? But be very sure you do what the trust deed requires you to do. Beneficiaries may have rights in trust deeds for reporting. I've seen some trust deeds where they say, trustees will annually report to beneficiaries. Well, you better do that then, because that is an instruction from the founder. And then a dispute resolution mechanism if we get stuck, this whole majority decision, unanimous decision thing. If we really get stuck, is there a dispute resolution mechanism that we can revert to? So you can see a trust deed is a very specific. It's not something you put in your bottom drawer. It's actually a living document for a trust that you can actually use to execute. So apart from that, we've spoken over and over about record keeping. So that's on the next slide. Record keeping is the absolute important aspect for a trust, and you have to be able to provide evidence, and we see that right through. Trustees have to keep records of all the decisions, so that's the overrider. Now we're into kind of this digital printed records manually. Go back to your trust deed and see if it allows for digital. I think it makes perfect sense with trustees sitting all over the world. We're trying to do things real time. So don't wait till the end of the year when the accountant does your financials and then work back and say, what resolutions do we need for the year? Do them as the transactions happen. We've seen too many times where trustees resign, people pass away, and then those resolutions weren't signed, which is going to become a big problem. Then I don't know, how many people know about the Doyle case. Doyle case trustees have got a responsibility to provide full trust administration reports and accounting records supported by vouchers, the court said in the Doyle case. So that is right down to the old check stubs they called. So you can see I can ask for invoices, literally as far as that. However, you can't ask trustees how they arrived at their decisions. So minutes of meetings probably going to be a little bit difficult. So for SARS, same thing. SARS's own record retention requirements. The Trust Public Control Act, I don't know who knows, you will have to keep records for 5 years after termination of the trust. So it's 5 years after the trust has been deregistered. Every single trust document. So you can see a document storage is becoming absolutely critical. And then some trustees have further requirements in terms of, how documents are to be stored, what are to be stored. So I think if something is going to help trustees to actually defend themselves, it is record keeping. So make sure, as far as possible, you've got resolutions, you've got minutes of meetings, you keep email copies, you keep correspondence, etc., etc. So let's just have a look at a very quick high-level checklist for trustees, and I think I'm running out of my time. Let's quickly have a look. So, and I think we'll go into these, in more detail in our next session. We've spoken about Section 9, the overrider. So, by the way, you cannot indemnify yourself against, any wrongdoing, any negligence in terms of Section 9(2). So that you can't override the act. So you will act with the necessary care, diligence, and skill. And you have to be able to prove that you can do it. Every trust has to have a bank account, Section 10. The trustees are required to lodge a trust instrument. Interesting, there's no time frame, especially with your amended trust deeds. There's no time frame in which you have to lodge, but the trustees have an obligation. So once you amend the trust deed, you have to lodge. Its obligation of the trustees. Trustees have to furnish the master with a change of address 14 days after such a change of address, which I don't think a lot of trustees know about, but that's what Section 5 is about. You cannot act without written authorization by the master in the form of a letters of authority. So that is Section 6. And the master may also require you to lodge security if so required in terms of Section 6. You have to register and identify trust property. We've spoken about the asset register, which is required for every trust. That's that section. And then we have to protect the trust documents. That's the 5 years, after the trust termination. Trustees are entitled to receive reasonable remuneration. So the master is relooking the Trust Property Control Act, and my input is we need a little bit more guidance, what is reasonable, and if the trust deed stated specific remuneration, then it basically overrides this provision. So it is problematic, but yeah, you are entitled by law. You need to account to the master when the master requires you to do so. Section 16 I use often when trustees are stepping over the line, so I get the master to compel them to report. Formal duties imposed by the trust instrument. So if the trust instrument asks you to do something and you don't do it, the master can take you to court to compel you to do it. Also, if you don't perform any duty imposed on you by law, same thing, the master can take you to court to do it. And then the trustees need to find unanimity in making decisions. There's lots of court cases, people use this beautiful, we got a majority rule, so we can outvote the other trustee and we don't even have to invite him or her to the meeting, we can go behind his back. That's not what it means at all. Trustees have to act as a unity. In other words, internally we can fight, we can disagree, we can whatever. Every trustee has to be part of that meeting. And so, by the way, a quorum is all trustees, not the majority that you want to use in your trust deed. So very important that all trustees kind of deliberate and then the majority can make a decision. So you have to give all trustees an opportunity to be heard. So that's very important. Act independently, we've discussed that earlier on. We've discussed the invest productively, wisely, in accordance with sound governance. We've discussed that. Trustees have to avoid risk. That is what, there's the Liebenberg court case where the mother, it's a testamentary trust, and the mother was a trustee, and she signed suretyship for the elder son. He was only one, I think, of 5 beneficiaries. And basically, it went bang, and the creditor called on the surety, and the objective of the trust wasn't met because the trust was set up for the benefit of all the beneficiaries. In fact, the termination clause said that they have to get a specific percentage on termination. So the trustee didn't act in terms of the objective of the trust. It was set up for things like maintenance, education, of the beneficiaries, and it only was solely used for paying on a surety that's gone bad. So I think it's very important to understand the beneficiaries in the trust and how they have to be treated. That Liebenberg case also referred back to that. And then you have to make proper distribution to identify beneficiaries and distinguish between income and capital beneficiaries. Again, you have to look at the objectives of the trust, and then on the beneficiaries what they ought to get. Even though it's a discretionary trust, it doesn't mean that if a trustee doesn't allow specifically, for business risk, that you can, you can just do as you wish. And then the correct number of trustees should be appointed. Go back to your trust deed. That determines, who needs to be appointed on the next slide. I think that's important, to look at the trust deed and make sure at all times, if there's a sub minimum, you have to make sure that sub minimum is on a letter of authority. If it's not, those trust decisions are not valid. It's also important to hold meetings of trustees and keep minutes. The sections I've recorded there. And we need to make sure we've got proper systems in place, because that's the only way you can make sure and you can demonstrate to anybody that attacks the trustees that you actually have applied your mind, you've acted in terms of the trust deeds, you had your proper documents, and you've got evidence for, you know, arriving at certain decisions. That is apart from the statutory duty that you have to keep records for 5 years after termination, and then obviously the SARS, that's, you know, the kind of rolling 5 years. Trustees are allowed to obtain expert advice and appoint their experts. Most trust deeds allow that. You know, you can't expect of trustees to know everything, so normally trustees allow for that. And then, like the overriding thing, you have to comply with all legislation. So when you look at all of that, does a trustee have any excuse? As Ricardo said earlier, you know, you can no longer claim ignorance. On the next slide. So I don't know, for you who are trustees, whether you remember ticking the form that you can see on the slide. It's called the J417. It asks you specifically, the master asks, does the trustee have knowledge and understand the law of trust? Now we've just had a brief look at some of the legislation, so you need to say yes or no. If it's no on any of these things, the master may require security, as we discussed in terms of Section 11 of the Trust Property Control Act, because why would they allow somebody who doesn't even understand the law to actually manage the affairs of another person and act, you know, would be able to act in terms of Section 9, which means you've got the skill. So you need to be honest when you tick yes or no, because if you say yes, you would have no excuse. Are you aware of your fiduciary duties and responsibilities? We've discussed that, so that's a quick yes or a no. By accepting your position as trustee, are you exposing yourself to criminal action in terms of Section 9? Do you know that? And then by accepting your position, are you exposing yourself for removal? Say yes or no. And then you have to tell the master whether you are going to exercise direct, special, personal control to maintain accurate records of the trust. So that better be yes, because you know, I think that's a Board of Trustees responsibility. So I think you need to be very careful if you answered yes to those and it's actually not a yes. And if it's no, the master would probably have required you to put down security. So I think you know, that kind of summarizes what's expected of you and whether you can get away with sorry, I don't know, or, you know, I'm not a trust expert.
Thank you, Fia. Thank you for that very informative talk and presentation. I think you have really, I think, set out quite succinctly the risks and, most importantly, the responsibilities that go with being a trustee. I see we have quite a few questions coming through. So if we can possibly just open up that while we moderate those. Just first up, Fia, you mentioned the word independent, and it's quite a buzzword. But is it what is the best practice and current position around independent trustees? Is it necessary, and who would qualify?
Yeah, I would say as recent as March 2017, but it's 3 years later, so it's been a while now, where the master brought out very firm directive in terms of the fact that they require the appointment of an independent trustee for every family business trust. Now, a family business trust is a family trust that can incur debts. If we just know a very nice case to you know, read for trustees to read is the old land bank case that you know, of 2005, where the court started saying we are getting tired of the abuse now. The land bank has been taken for absolute right. Not the right number of trustees were on it. Was the family. It was an absolute mess. But so there the court said they're now tired. It would be really nice to have an independent trustee. And then only in March 2017, the master brought out a directive and said from now on you will have an independent trustee, and it defined there what it could be. So it needs to be an independent person by blood or otherwise. So my otherwise is it could, your best friend can't be. You know, I always ask the people who register the trusts. When I said this is my independent trustee, I said, right, when you get divorced one day, would your wife agree that your best friend was really an independent trustee? I think it's something in your gut, right? You know right. Whether that person is independent right. or not. Yeah. So the otherwise is really the vague area, but yeah, every family business trust has to have it now, a new one, and then we said when they replace trustees now, the master requires independent trustee as well.
Thank you, Fia. Fia, can you resign as a trustee?
Every trustee's got a right to resign, even if the trust deed allows for it or not. Most trust deeds do, but every trustee's got a right to resign.
Right.
You just have to make sure that you follow due process if there's a process in the trust deed.
Okay, thank you. And Fia, if a founder is late or is deceased, do you need to amend the trust deed to reflect that?
Absolutely not. Although some of the, I think that's important, just general amendments, because the trust is a contract. As long as the founder is alive, please go and amend your trust deeds, because he's a party to the contract. The moment the founder falls away and you don't have a proper amendment clause in your trust deed, you may have to end up to go to court to have that trust deed amended. So rather amend it while the founder is alive. But once the founder is deceased, hopefully you haven't given him rights that, it's just not practical when he's no longer there. You don't have to amend the trust deed after the founder's death.
Okay, thank you, Fia. And at what point are trustees recognized? Is it when appointed by beneficiaries, other trustees, or when confirmed by the master in the LOA?
Yeah, so the date is the date of appointment by the master, evidenced by a letters of authority that list all the trustees' names, whether you appointed as a new trustee, whether you removed as a trustee. You only removed when you actually, no longer on the letters of authority. And then obviously you have to follow the process in the trust deed, which would happen before that master would issue the letter of authority.
Right. Okay. Perfect. A question from Anonymous. Are you saying if a trust deed records that a majority of trustees is sufficient for a meeting quorum, or is it to pass a resolution that is not valid because of case law?
Yeah, I think a lot of trust deeds, so I think you must understand a trust deed can't override law, and there's sufficient legal precedent that, demonstrated that a quorum is all the trustees, which means all the trustees have to be at least at the meeting or be notified of the meeting.
Yes.
And been given opportunity. I mean, if somebody's not pitching over and over, you can't not take decisions, but you have to give them an opportunity to participate. But when it comes to voting and the trustee allows for a vote on that specific issue, then you could actually use the majority rule if the trustee allows for it.
Right. Okay. Yeah. May beneficiaries demand reasons and an extract of minutes? Is that available for beneficiaries?
As I said, in the Doyle case, I don't think you can question, how trustees deliberated, who they're going to give what, and one they're not giving to one and giving more to another. You can't question that. You can, however, ask for a resolution where they've actually, made their decision in terms of the facts, in terms of who's getting what. You can know who got what. But I mean, it's not for you to know and to question how they arrived at their decisions. Okay.
Now, a two-part question linked again to meetings, Fia. Are trust decisions being passed by a majority of trustees? Part one. And the second part is, if a trustee disagrees with the majority, how do you record that disagreement?
Yeah, so that's a very important question, especially the last part. So the first part is you can have a majority decision. And the second part is it's very practically difficult, because remember I said the legal precedent said that the Board of Trustees go out as a unanimous vote. So we can't tell somebody, only the majority of us agreed. People don't care. It's a trust decision, which means although it's a majority decision, all trustees have to sign a resolution. Now, if I am disgruntled and I didn't agree, I'm going to refuse to sign. So we're sitting with a very, a big dilemma where we say to people, just record the fact. If somebody refuses to sign, have evidence, possibly emails, letters, whatever, where you ask them to sign just to have evidence. So the decision will stand as a majority decision. A third party want to rely on a Board of Trustees decision where they want to see every trustee's signature. So if you can't get it practically, I suggest just write a reason that been at the meeting, disagreed, we use the majority vote. Okay, thank you,
Fia. Here we are running out of time, so if I may just take one more question, if that's okay, and then we'll close. There was a comment made by Gianna van Borman. Could the obligation to consult with the beneficiaries be explained further? She was referring to the Doyle versus Board of Executors.
Yeah, I think consulting, this question I could read different ways. So it is often nice for trustees to consult beneficiaries, to understand their needs and to, approve distributions. However, trustees don't have to consult with beneficiaries. They don't have an obligation. The Doyle case revolved all around disclosure of information. So that decision's already made, and so that beneficiaries can actually look at documentation supporting cash flows, supporting investments, look at resolutions, etc. So that is more, information gathering than consultation before a decision is made.
Okay. Thank you, Fia, for that. If I don't mind, I am going to ask that we just take back, just close the talk at this stage, if that's okay. So thank you for your contribution.
Thank you so much.
All right, thank you very much for attending. We have had a number of questions that have come through from the Q&A session, and so what we will do is we will actually reply to all the questions that were asked, and we will share it with all the attendees on today's call in a written document. So thank you for your participation, and thank you for joining the conversation. There's lots we can talk about, and this series of Talking Trust will continue. Our next edition will be hosted on 24th of June at 2:30 p.m. and the topic we'll cover then is Back to Basics, Trust Tax 101. So now that you're aware of the responsibilities and obligations of your role as trustee, in the next talk, we will recap your trustee responsibilities under tax legislation. So if you have not already done so, please do RSVP to join us on 24 June. And in the interim, if you have any questions related to the administration of trusts, please do reach out to BDO Trust Administration directly. Stay well, stay safe till we connect again. Goodbye.